Welcome. Today you will hear from Snell and Wilmer attorneys Rebecca Wintersheet and Joshua Woodard as they explore the impact of Prop 206 and discuss the possibility of President-elect Trump rescinding the numerous executive orders signed by President Obama and what impact that would have on employers. There are two ways in which you are able to ask questions of the presenters. Throughout the presentation, you have the option to privately submit questions online using the chat feature of the webinar. Or if you are listening to the audio portion over the telephone, we will open the phone line so you have the option to ask your question directly of the presenters. If you experience technical difficulties, please type your concerns into the chat feature or contact the help desk at 877-297-2901. I would now like to introduce Snell and Wilmer attorneys Rebecca Wintersheet and Joshua Woodard, who will begin the presentation portion of today's event.
Good morning, everyone. This is Rebecca Wintersheet at Snell and Wilmer, and with me is Joshua Woodard. And we have Jennifer Yee, whose name appears on the cover sheet, the first slide up here. She is not with us today, but wanted to include her name. She was instrumental in putting together the legal alert that went out on the topic of Prop 206, and she is available, obviously, to answer questions following the webinar also. So it's been now less than a week since the big election, and at the national level, I think it's fair to say that the presidential election was a surprise, and we are all trying to sort of figure out what the impact is going to be. And at the state level, obviously, with the passage of Prop 206, there is going to be impact on employers. So we want to talk about both of those. Next slide, just a second. Okay, and we do want to have some time afterwards for questions and answers. So the first topic in terms of the impact of the Trump presidency on employment and immigration. You know, the campaign really on both sides was fueled with a lot of promises. Now that we have President-elect Trump, who is going to be inaugurated not too long of a future here, we have both the Democrats and the Republicans kind of wondering whether the statements and promises of Trump the candidate will be the actions of Trump the president. We've already seen some softening on some of the promises, for example, to repeal Obamacare. Recently, there's been a little movement back saying, well, probably pre-existing conditions and coverage till kids are age 26, might be some of the aspects that would remain on Obamacare. It remains to be seen sort of if there's going to be a softening on some of the other positions that were taken by Trump during his campaign. We do know that a couple of Trump's promises could have immediate impact on employers really in Arizona and across the country. So about a month or so before the election, Trump outlined what he wanted to do within the first 100 days. But probably even more significantly, he talked about what he wanted to do on day one, and there were 5 points that he talked about. And I want to spend just a few minutes talking about those. First of all was to cancel all of the unconstitutional executive actions, memoranda, and orders issued by President Obama. And we're going to talk a little bit about what that might mean for Arizona employers. Secondly, second point on the first day, he wanted to begin the selection process to replace Justice Scalia. Third was canceling funding to sanctuary cities. Fourth was removing more than 2 million criminal illegal immigrants, and then canceling the visas to foreign countries that won't take them back. The second part of that's very interesting because it's not really clear what is meant by that. For example, if Mexico won't take back the illegal immigrants who have committed crimes in the United States, it's unclear whether that means that he's going to cancel then the visas of all the Mexican citizens who are currently here in the United States. And then finally, the fifth point is suspending immigration from the terror-prone regions where vetting of those potential immigrants can't safely occur, and then really submit everybody to what he calls extreme vetting. And extreme vetting, at the very least, would probably result in much longer processing times for visas. So let's talk about the executive orders. You know, he's got, as new president, he has the ability to rescind those really with a stroke of a pen. It's an immediate rollback. He could issue a blanket order that rolls back every executive order that President Obama signed if he wanted to. But I don't think you're going to see that happening because of the consequences. You know, after 8 years under the Obama administration, some of those executive orders have been in place for quite some time. And there's industries, employers, and individuals who have relied on those, have sort of organized themselves according to those rules. But that is certainly a possibility. And there's a history of the presidents, you know, using executive orders. They've been used fairly regularly over the last 25 to 30 years, especially where you have presidents that are frustrated because they can't get measures through Congress because they're controlled by the other party. And some of those executive orders have, you know, quite a bit of staying power because they do continue on into the next administration unless the next administration revokes them. For example, one good example is Executive Order 11246, which was signed by President Johnson back in 1965. And those of you that are federal contractors know that that one is the one that imposed on federal contractors the duty to have affirmative action plans and non-discrimination. And, you know, it may be interesting because President Obama may see a lot of his executive orders canceled out, and he, in fact, rescinded 3 of his predecessors' prior executive orders when he took over, those dealing with some labor issues regarding government contractors. So it's not unheard of to have, for example, a Democratic administration pass executive orders, have those revoked if the Republicans take over the next time the presidency, and then if the Democrats come back in, some of those get revived. And so it's a kind of a never-ending process of executive orders.
You know, and Becky, and good morning, everyone. This is Josh. It's interesting when you mentioned that President-elect Trump's tone has been modified just a bit. He had a meeting with President Obama, I think on Thursday. It was scheduled for 15 minutes. It ultimately went 90 minutes. And coming out of that, it's interesting, the President-elect was saying, oh, we talked about a lot of good things that are working and some things that had challenges. So we're even starting to hear a little bit of a different tone off the campaign trail.
Yeah, absolutely. You know, the other thing to kind of keep in mind, too, is beyond the executive orders, you know, he could order agencies to begin the process of replacing some rules that were formulated under the prior administration. He could halt rulemaking if it's not been finalized yet. But generally, if the rules have been finalized, there's a very detailed process that they'd have to go through to rewrite or change them, including, you know, proposing them, having a public comment period, reviewing the substantive comments, and then if they do issue rules, you know, addressing those comments. And that process generally takes, you know, months and sometimes really years. So we might see that. But there's one exception to that, I would say, and it's only been used once. And that is under what's called the Midnight Regulations. And it's really regulations that were finalized sort of in the waning months of an administration. So if he entered the office, if Trump enters the office, you know, what could happen under the Congressional Review Act, Congress could pass a resolution of disapproval on any recent rules that would basically nullify that policy. And again, it's only been used once in the history of the country, and that was by Bush to nullify a workplace ergonomics regulation from the Clinton administration. So it'd be a little unusual. So let's talk a little bit about, you know, what predictions we might see. And, you know, a lot of this is sort of like looking into the crystal ball and trying to figure out, based on what Trump, the candidate, said he was going to do. I think one of the things we'll probably see is some action on the 2012 executive order called DACA, or for the Dreamers. This is the one where if you had the kids who entered the United States illegally and then lived here, that they got, under this 2012 executive order, the ability to obtain work authorization through employment authorization documents, EADs. They could get Social Security numbers, and they were protected from deportation for kind of a period of 2 years at a time. there are currently 1.2 million Dreamers in the country, and at least 50,000 of them are here in Arizona. And you might think, well, I don't have to worry about that because I don't really sponsor foreign nationals, but you may not even realize that you have DACA folks on your payroll, because for HR, these are folks that would come in and be able to fill out the I-9, that give you the EAD, that has work authorization, and but for maybe putting it into your, tickler to remember that in 2 years you got to double check that those folks are still valid, they may be on your payroll right now. And so, there may be, if he would revoke that, that would eliminate immediately these folks' ability to work in the United States. Another possibility is the National Labor Relations Board, and looking at who has signed up. Most of you, not all, but are not unionized. But as you well know, the NLRB in the last several years has really expanded its reach into private employers, everything down to, looking at handbook policies and social media policies, and, bringing unfair labor practices against companies that are not unionized. Well, right now the board only has 3 members, 2 Democrats and 1 Republican. And I think what we could probably expect is probably 2 Republican appointees in 2017. And what impact that might have on recent labor law is, at least what's being said right now, is probably a change in sort of the tenure of, or a change in the tenor really of the National Labor Relations Act. Then we move on to the Supreme Court, a hotly debated argument in certainly the last year of President Obama and his trying to appoint someone to the Supreme Court. We do have the Justice Scalia position that, remember, Scalia was appointed by Reagan, and we've got some other folks on the Supreme Court that are aging. We've got Justice Kennedy, who is over 80, was appointed by Reagan. We've got Ruth Ginsburg, over 80, again, appointed by Clinton. And then we have Stephen Breyer, who is, I think, 78, was an appointment by Clinton, too. So, the face of the Supreme Court, depending on whether or not those folks, those 3 individuals, remain on the court or retire, could dramatically change, the face of what comes out of that institution. Then we have government contractors. Under the Fair Pay and Safe Workplace Executive Order, which was 13673, we've got what's been called the blacklisting rules, which require, certain government contractors to disclose publicly if they had violations for the past 3 years. Now, part of that has been the basis of an injunction. In October of this year, a federal judge in Texas blocked part of that law. But there's another portion of it, which is the paycheck transparency provision of the order, that probably will take effect in January of 2017. And that has the contractors with $500,000 or more in contracts have to provide employees with, a document talking about how many hours they work, the overtime, deductions, whether or not they're independent contractors or employees. So that may well take effect. Then we have the OFCCP final rule from August of this year under Executive Order 11246. Remember, that's the one that President Johnson signed back in 1965, but it's been changed and updated over the time. And part of that prohibits contractors from paying differently because of sex, and making them give the same type of benefits. It requires workplace accommodations like bathroom breaks and light duty assignments because of pregnancy or childbirth. Those are not too unusual. But then you get into the other portion of it that talks about sexual orientation and gender identity. And some of the points under that is the infamous bathroom issue and what's going to happen about, allowing a person to use a facility that's consistent with the gender that they identify with. And obviously the idea that sexual harassment that's prohibited also includes gender identity harassment. Are there other executive orders at risk? Well, probably. Executive Order 13706 dealing with sick leave, the final rule has certain federal contractors having to comply by January 2017, and that's the one that provides 1 hour of paid sick time for every 30 hours worked. And that is going to sound very familiar once Josh starts talking about Prop 206.
And just be cautious, too, even if soon-to-be President Trump rolls back some of these executive orders, there's a patchwork of both state and local law that may fill in the gaps for these employers. For example, Tempe and Phoenix has sexual orientation discrimination and retaliation prohibitions, as do a number of other local cities, even though you don't see it at the state or federal level.
Then we move to the next one. Thanks, Josh. Talking about some additional immigration, and immigration kind of seems to be a theme because it was very much a theme in Trump's candidacy. One of them is, will we see something similar to Arizona's SB 1070 at the federal level? Chris Kobach was one of the authors of SB 1070, and he is now Kansas Secretary of State. And I have on the slide, he may be on the Trump's transition team. The last thing that I read this last weekend is that he is on Trump's transition team, at least as far as immigration goes. So that would be very interesting to see what happens there. E-Verify, although we have it in Arizona, some of you are multi-state employers, and it would not be beyond the realm of possibility for there to be a federal requirement for all states to comply with E-Verify. Then the next one is sort of interesting, the tightening or elimination of some business immigration visas. A lot of talk from Trump about his unhappiness with NAFTA. Well, part of that's obviously dealing with trade, part of that's dealing with immigration. And the TN visa is one that is available and a relatively easy visa to get for Canadians and Mexicans. And if that goes away, that's going to put a lot of stress on the remaining visa types that are available to bring in folks to help, U.S. employers. On the H-1B visa, a lot of talk about requiring some kind of a testing of the labor market so that before you could even sponsor an H-1B, you would have to show that there are no other U.S. citizens or permanent residents that are qualified for that job. And those of you that have to go through the H-1B process, you know that last year there was a lottery, as there has been many years before, and only about 30% were even selected in the lottery. So there's a huge amount of pressure on the H-1Bs to begin with. Under the H-2B temporary work visa, usually that's for seasonal type work, for landscaping work, and it's interesting because the question is which Trump will show up. Is it the anti-immigration Trump where he wants to really shut down a lot of these programs, or, as some people in the newspapers will say, is it the Trump who used those very visas to develop some of his own real estate work? So that's a big question mark, really. I think what we will see is longer processing times. There's also a couple extra points I didn't put on here. One is Trump has talked about having some kind of an ideological test for immigrants coming to the United States. And some view it as sort of a dialed-down version of his previous comments about, banning Muslims. Another point is talk about imprisoning immigrants for at least 2 years if they enter the United States illegally. Obviously, that has a lot of, costs associated with it also. We've got child care and the question of Ivanka Trump's proposal that she was making for 6 weeks of paid maternity leave, something that you usually would not see out of a Republican administration, but that's something that with her now being on the transition team, it'll be interesting to kind of track that and see what happens there. A lot of talk about possibly getting Congress to repeal the Dodd-Frank Act that was signed into law in July of 2010. If that happens, obviously that's going to have a big impact on the financial services industry. But, in the end, we're kind of looking at, what's the tone at the top going to be? And obviously, President-elect Trump is going to set that tone, but it's going to influence, the agencies that we deal with. Under the Department of Labor, we've got the new DOL overtime rules, wage and hour issues. Under the EEOC, we all deal with, the EEOC sometimes more often than we want to. But the question is, how aggressive, will they be, and where will their priorities be? Chair Yang's term at the EEOC ends in 2017. So, Trump is going to appoint someone, and the question is, will that someone be, more conservative? You remember in 1982, President Reagan appointed Clarence Thomas, Supreme Court Justice now. Under DHS and USCIS, we've got the issues of visa processing and the vetting issues that Trump had talked about. And then with ICE, the question is, are we going to see an increase, a ramp up in the audits of employers in complying with the I-9? Are we going to see, more aggressive action in terms taken against companies that do hire unlawful workers? And finally, there's been some talk by Trump about setting up a separate, he called it deportation force, outside of ICE to remove the 11 million undocumented immigrants. I've noticed a softening of that. That was, a pretty bold statement at the time, and I think that's probably dropped down in terms of the list of immediate action items. But, those are some of the things that really come to mind when we talk about Trump presidency. And right now, we're kind of guessing, but we're trying to make educated guesses, and I think we need to kind of continue to look at who's going to be on the transition team, who's going to have his ear in terms of what's going to happen, not only on day one, but really throughout his presidency.
You could easily see some funding being switched from agencies like an EEOC and Department of Labor into ICE and Department of Homeland Security.
Right.
So you could see a shifting in priorities for sure.
Absolutely. All right, Josh, I'm going to turn it over to you at this point in time.
Okay, great. Thank you so much, Becky. Everyone on this webinar, we should probably meet back here same time, same place a year from now, and we'll see if those predictions come true or not. So we are going to be shifting to Prop 206, moving from the federal level down to the state level, and looking at what passed here just about a week ago by a wide margin, too. It was up to 60%. Passed Prop 206, which is the Fair Wages and Healthy Families Act. I kind of chuckle at the title because it deals with people who are not healthy and giving them paid time off. But nonetheless, it's the Fair Wages and Healthy Families Act. And this really does alter the landscape quite a bit. And there's going to be tens and, in fact, hundreds of thousands, it's been estimated, of folks who will get a raise here coming up in just a couple months and some targeted raises later, and also providing paid sick leave to all private employees, for the private sector employees, kind of from no matter how small you are to how big you are. We'll talk about those accrual rates. So dealing first with the minimum wage, and this has come up from time to time in Arizona, as it does from time to time at the federal level. But under current law, our Arizona minimum wage is $8.05 an hour. But it's going to start ramping up. You'll see on the slide there, starting in January, it's $10 an hour, and it slowly goes up in the next 3 years. When you hit 2020, it goes up to $12 an hour. Now, what's interesting here is there was such a big push nationwide to get to $15 an hour, but those folks who were proponents of 206 decided to limit it at 12. So very, very interesting in that perspective, and I think we're a little different than some of that national push. But there you have it. It's going to go up to $12 here in a couple of years. Josh,
I had a client once ask if there's any exceptions for nonprofits, because this is a big jump from almost $2 jump.
Yeah, and there's not the way it's currently written right now. It applies to all employers, private sector employers. And then starting in 2021, it's going to be indexed to the consumer price levels. And so we saw that push at the national level as well in terms of the new Department of Labor salary regulations. That's tied to the index as well. So the proponents of these laws are saying, look, we're not going to go through this again. It's going to automatically increase depending upon the cost of living. So, and sure enough, that's what Arizona did as well. There is still a tip credit for the minimum wage earners, and so those who are subject to tips, and we could probably talk for an hour on how to properly tip, but it's probably beyond the scope of this particular seminar. But you can take a tip credit, and for those employees who actually receive tip income, they can earn $3 per hour less than the minimum wage. So come January 1st, tipped employees can earn $7 an hour, assuming that they meet the other requirements of being a tipped employee. Now, on the minimum wage, there are some notice and record-keeping requirements, and employers have to post a notice of employees' rights under the Act and keep payroll records for 4 years. Now, there is a sample notice coming out from the Industrial Commission here. We anticipate that here in the next month or so. Now, what's interesting is, as Prop 206 is written, it has to be both in English and in Spanish. There's no carve-out that says, hey, if you have a Spanish-speaking employee population, you have to post it in Spanish. It says it has to be posted in both English and Spanish and other language as may be determined by the Industrial Commission. But I think for now, keep that in mind. And I'm assuming the model notice that's going to come out from the Commission is going to be kind of a dual notice where, one half will be English and the other half will be Spanish, but that'll be kind of interesting. The other requirements in there, it has to talk about how the terms of the sick leave are guaranteed by Prop 206 or the statute that it'll get rolled into, and that retaliation is prohibited. So there's some very specific things in 206 that the notice is going to have to say. In addition, it has to give agency names and phone numbers, and it basically is going to be a roadmap for people to figure out how to file a complaint if they think there's a violation here, and that's all got to be in the notice.
And Josh, I saw too on the Prop 206 that employers have to permit employees or their designated rep the right to inspect and copy payroll records.
Yes.
Yeah. So if you have an attorney, somebody's a current employee who has an attorney, the attorney can come in and say, I want to see and copy those payroll records.
Yeah, absolutely. Yeah. It is a broad statute. Now, what's interesting here is there's some other some cities that may provide a higher minimum wage. For example, Flagstaff just voted in $12 an hour, and that's going to continue to increase at not less than $2 above Arizona's minimum wage. So that is going to continue to outpace 206. And so for those folks who might be operational on a statewide basis, we're going to have to keep those different cities in mind. And this is nothing new for those of you who may be operating out of California. There's a mishmash of local regs and paid time off and minimum wages that really span the state. And so California is muddling its way through that patchwork of regulations, and we're going to have to start to do the same here, just to keep an eye out for that. Now, in terms of the paid sick leave, so transitioning from the minimum wage to the paid sick leave, so this begins July 1st, so we have a little bit of time to figure this out. So we're just over 6 months here, and it accrues at the same rate. There's been an awful lot of confusion here. So for every for every 30 hours worked, employees get 1 hour of paid sick time. Now, if you are with a small employer, or if you are a small employer with 14 or less, so as it's written, it's fewer than 15 employees, they clip away up to a maximum of 24 hours per year. So basically 3 paid sick days if they're 8-hour days. If you are with a large employer, 15 or more, you clip away at for every 30 hours worked, again, 1 hour of paid sick leave, but your max is 40 hours a year, or 5 days. Now, for those of you who are good at math, I had to pull out my calculator to figure this out, but it accrues faster than you would anticipate. So that accrual rate works to about 69 hours per year, just a little over 69 hours per year based upon a normal 2,080 hour a year number of hours in a year. So it clips away quicker. And so what that really is saying is employees are going to hit their maximum sooner than through the end of the year. And so that's kind of an interesting anomaly there a little bit. Now, exempt employees are assumed to work approximately 40 hours per week, and so you accrue based upon that amount.
We had a question on both coming in from here and another question that dealt with, temporary employees or part-time employees. How do you count those within just a regular work week, or is it 30 hours even outside a regular work week for those people?
Oh, it's a great question. So how that works, it's not based upon simply a work week. It's so if you have somebody that, let's say at a small company, so let's say we are up to 24 hours a year that can accrue and you cap at. And so if you've got a small employer, and so what you do, and let's say someone's working part-time, and let's say they work 10 hours a week, just for example. Well, after 3 weeks, so 10 hours a week times 3 weeks, you get to that 30 hours. Well, after that third week, they will have 1 hour of accrued sick time. And so it's not on a week-by-week basis. It's kind of a running total as you go along, currently as it's written. So in terms of the reasons for leave, there are a number of them that are listed in Prop 206. And so the ones we would certainly expect is if the employee has a physical or mental condition that needs, and think of somebody with the flu, that's probably the easy one that we all normally think of, or to care for somebody in their family. Now, let me just pause here. The family is defined pretty broadly. It's not only spouses and children, but if you stand, for example, in the place of a parent and you are acting in loco parentis, so you're acting as if you're the parent and somebody gets sick in the household, then you can take and utilize this paid sick leave. Domestic partners are entitled to it. So family members are very, very broad here. So it's not only for the employee's own physical or mental condition, it's also for the families. Also, if there's a public health emergency, think of like a flu epidemic or something where they're telling people to stay home, that could trigger the use of paid sick leave. If there's domestic violence or sexual violence or stalking of either the employee or the employee's family member, that's going to trigger the ability of employees to use this leave as well. And then there's some other nuances in there, but those are the main categories. So really think of physical and mental care for employees or the families, or the effects of domestic violence, sexual violence, or stalking.
And some of these, Josh, would fit, or at least a couple of these might fit under an FMLA if you have employees under FMLA, and I think the argument would be that you would consider this paid sick leave and you would treat that concurrently with the running of FMLA.
Yeah,
absolutely. Do you agree with that? Okay.
Totally agree with that.
Okay.
Yes.
Before we leave that, we had another question to pop up here. It's kind of on the temporary issue of temporary employees, but it says, what about interns and sick leave accrual? Is there any exemption for interns or anything like that, or as long as they're employees, you'd have to provide the sick leave?
The latter there.
Yeah.
As long as they're employees, I think they are starting to accrue sick leave in that sick leave bank up to those accrual maximum. So if someone is in a small employer, you max out at 24 hours. For a full-time, or for a large employer, you max out at 40 hours per year.
Okay.
So in terms of the notices and paychecks, this is something that the employers should probably start dealing relatively soon. I mean, we do have till July, but soon with their payroll companies, or if you do it internally with your payroll departments. And I'll explain that of how serious that can get in just a minute. So, as we talked about before, there is a notice that has to be provided in the workplace. That's coming out from the commission, so just keep your eyes peeled for that. And we'll try to get out a workplace alert, a legal alert on that when that does come out. But in terms of what you have to do on the paychecks, so what has to be listed on the paychecks is the amount of paid sick leave available to the employee, the amount of sick leave that's been taken by the employee in the year to date, and the amount of pay the employee has received as paid sick time. So it's really so the employee knows exactly where he or she stands in terms of what's available, what have I accrued, what have I used, so they have an indication. Now, there are some severe civil penalties associated with this if there's violations of Prop 206 that can get up to $250 for a one-time violation, but then $1,000 per recurring violations. Now, there's no definition in Prop 206 as to what that means. However, I think there could be an argument, certainly, that every paycheck that does not have that on there, that in theory could be $1,000 per paycheck. And so for those people who pay weekly, obviously we can do the math in a year. That's going to really, really add up in a hurry.
Yeah, and so I guess I would just add, because I've heard some of my clients talk about this, that, if you're fairly sophisticated and have a really good system in place, and a lot of them use UltiPro or one of those, just make sure that your system is set and ready to go. But if you're a smaller employer, you're going to have to be able to be tracking these things with regularity and with accuracy. So I would say for HR folks, take a look at whatever system you're using and make sure it's now capable or will be capable of tracking this.
Yeah, absolutely. And rolling that information onto the paycheck as well. Yes, definitely. In terms of sick leave carryover and how that works. So employees can carry over earned sick leave subject to the limitations on accrual and usage. So, and what that means is, again, they clip away pretty quickly, but it is capped depending upon how big the company is, either at 24 or 40 hours. And so once they hit the cap, they hit the cap. That's fine. But whatever they don't use, they can roll over to the next year. Now, employers can avoid that rollover if they want, but the employer has to pay out that earned sick leave. So at the end of that year. So let's say, for example, that you're on at the end of the 12-month period that I work for you, Becky, and I've taken only 1 day of paid sick time, and I have 4 left for me to take. So Becky, as my employer, could do one of two things. She can say, hey, Josh, you can roll over those 4 days, or she can say, no, Josh, you can't roll over that, but I'm going to pay you these extra 4 days. And then what Becky has to do, if she pays out that unused time that I have because she doesn't want the rollover, then what happens, let's just call it, we're on a calendar year, come January 1, Becky has to grant me the full allotment for my next year of paid sick leave. So let's say I work for a big employer, I get 40 hours a year, I get paid out at the end of last year. Becky has to say on January 1, hey Josh, I paid you out, here's your new full 40 hours that is available to you immediately.
I have a question here. It says if someone uses their 40 hours, let's see, someone accrues their 40 hours and then uses 20, do we have to allow them to start accruing again? I think they're going to be capped at the amount, right?
Yeah, so yes. So it's all based upon a 12-month period. And so if they've accrued up to 40 hours and then they start using that, you don't have to give them more. I mean, you're still capped at a use and accrual within a 1-year period of 40 hours.
Right.
For large employers.
And it says if they don't use any, so you have someone that's accrued 40 hours and they didn't use any, the question is, do we have to allow all of this to roll over? Well, they're still going to be limited by the next year period. You only have 40 hours.
Yeah.
So you're not going to roll over 40 and get another 40.
That's correct.
40.
You hit a cap on accrual and usage.
Right.
It's all in one. So whenever you hit that cap, you hit that cap. Or you can pay it out.
Right, you pay it out. Yeah, one of the questions that come up here a couple of times, interns, we talked a little bit about temporary employees or reduced worker employees, and the question is, what about interns that don't get paid? I think that probably goes back to the definition of employee under Arizona law.
Yeah, and the intern, at least at the federal level, has been a big deal for the last 5 years or so, and a lot of agencies namely the Department of Labor, is really cracking down on that. And so if there are unpaid interns, it would be wise to take a peek to make sure we have them classified properly. because it can be tough to limit, to have interns who are unpaid. But if they don't fall within the definition of an employee, they wouldn't be entitled to this. But I'd be cautious about that unpaid internship gig because I think it's hard to fit within that box for sure.
A lot of litigation on that recently.
Yeah, absolutely, absolutely. Okay. In terms of documentation, there are a number of types of notices that are acceptable from employees, and it kind of depends upon what type of leave is taken. For example, you can require, if it's 3 or more days of paid sick leave, you can require a note from a healthcare professional, but that is sufficient. You can't require beyond that. If it is a domestic violence situation, there's a bunch of documents. It could be from a law enforcement officer, a counselor, a protective order may do it, a signed statement by the employee may do it. And so the statute actually enumerates a number of different ways. Now, what's interesting, and we have to be careful here, is an employer cannot require an employee to disclose the details of the health condition. And Becky, I know this is a little bit more your area about how much can you inquire under, for example, the ADA and the FMLA, and those have some different standards. But under Prop 206, we have to be careful if someone says, hey, I need a paid sick time, and let's say they're entitled to it, they've accrued it, and it's their right to use it. An employer cannot inquire into, well, tell me about your health condition.
Yeah,
it could run into some other ADA problems for sure.
But it's very clear in this statute that you cannot ask that.
Absolutely. And on the domestic violence side and abuse or stalking side, you can't inquire into those details of tell me what happened, tell me who's stalking you, tell me who's the victim. And so we have to tread carefully there because, again, the monetary penalties here and some other issues I'll get to in just a moment in terms of some presumptions are difficult. In terms of increments, this has come up just in the last week. I fielded a couple calls about this. Is how do you track this and how can you allow paid sick time to be used? Well, employers have to allow in the smaller of either an hour or the smallest increment that your payroll system uses to account for absences. So I'm not aware of a bunch of employers that really track less than an hour, but there it is. If you allow employees to take a half hour of PTO time, for example, like they want to skedaddle Friday at 4:30 to get on the road a little sooner, and you say, sure, we'll ding your PTO bank by half an hour, well, then you got to allow the paid sick leave in a half-hour increments. If you only do it by an hour, then you're going to get to an hour, but it has to be the smaller of the hour or the smallest increment that your payroll system allows.
You know, where I see this creating a problem, Josh, is it's very similar to like the FMLA issue, particularly with exempt employees, where oftentimes people will just take time off and nobody really cares because as long as you get your job done, that's all fine. And no one really, many of my clients anyway, will come and say, well, we never really tracked this person's, FMLA because they're only gone a day, or maybe a couple hours here, a couple hours there. Well, under the FMLA, you can retroactively, as you know, designate some leave as FMLA. I didn't see anything about retroactive designation. So if you have an exempt employee who takes a bunch of time off, maybe it's almost intermittently, but we don't count it. I don't think Prop 206 really tells us anything about being able to go back and recapture that time or ding their PTO bank, right?
Yeah, no, it doesn't. It's silent to that issue. Yeah, that's an interesting point with that interplay with the FMLA for sure. In replacement employees, companies cannot require the employee taking the paid sick leave to go find a replacement. And this can be a big issue, especially in the construction world, that say, look, if you can't be there, Josh, to do this portion of your construction, you got to find somebody to fill your spot. Well, you cannot do that here. And this really becomes a protected leave in large part, assuming that the employee is otherwise qualified. There are some other miscellaneous protections. For example, you can't count the use of paid sick leave as an absence that leads to discipline or termination. Now, where this is likely to come up is if you have a point system at work, and Becky, I know you and I have talked about this before, we're not huge fans of point systems, and if you say, hey, if you rack up 15 points, then you're fired, and if you rack up 10, you get a written notice, and 5 points, you get a verbal notice. Well, under Prop 206, you can't count this towards discipline or termination. So this really does become a protected leave that you can't otherwise discriminate or retaliate against. Now, what's interesting here, and this is not in the slides, but this will be interesting and worrisome to all the employers out here. There is a provision of 206 that says if there's an adverse action taken within 90 days of the use of paid sick leave, or informing of someone of paid sick leave, or helping someone take paid sick leave. So let's just call it the easy example of I take a paid sick day off. If I get terminated or otherwise disciplined inside 90 days of taking that paid sick leave, there is a presumption that there's a violation of 206. Now, if that doesn't worry you enough, this one will. The question is, how do you overcome that presumption under the law? Well, it has to be clear and convincing evidence that you fired me for some reason other than my use of the paid sick time. So, clear and convincing is a pretty compelling standard. It is not a simple more likely than not. It is well beyond that standard. So it's somewhere between more likely than not and beyond a reasonable doubt. Clear and convincing is some heightened standard that a company is going to have to show that says, hey, I didn't fire Josh because he took a paid sick day. I fired him because he was stealing from the petty cash drawer. I mean, it has to be pretty clear that you took action against me for something other than paid sick time.
I think plaintiffs' attorneys are going to start salivating with that standard, because that is a really tough standard to overcome.
I think that's going to be the area of this litigation.
Yeah, and I think what you're going to find is, and maybe this is a little, that's the right word I'm looking for, but you're going to find probably employees who like to abuse and misuse the system, that they find themselves maybe on the cusp of having some discipline, and they're thinking, oh, I've got some sick days banked up here. I'm going to use a sick day and throw a kink in the whole system of, well, would you have been terminated or disciplined anyway, which, comes back to the importance of always documenting what you're going to do, even if you haven't taken that action yet. So if you're planning on terminating or giving a discipline to somebody, somewhere document that, because the next day the person could be taking the leave, and you may rely on that documentation to show, hey, I would have done that anyway because here's my evidence of it. But I can see people abusing that.
Yeah, and that's a great point. And the people on this call, I know, and either from your own counsel or from us, we often chime in of, is it documented, did you document, when was it documented, and it's going to become critical under at least Prop 206 to make sure those frontline managers are doing concurrent documentation and not a retroactive documentation, just for the very reason you mentioned, Becky, for sure.
We have several questions on termination, what happens upon termination, and Josh, I think, is going to be covering those in this next slide or two.
Yeah, excellent. So there is no need to pay out the paid sick leave upon termination, but if the same employee is rehired inside of 9 months, that unused accrued sick leave is reinstated, and the employee can use that balance immediately upon rehire. And another question came up as well, and I don't think I have a slide on this, but we talked about that this paid sick leave goes into effect July 1 of 2017. If you hire somebody after that date, so call it July 1 or later, July 1, 2017 or later, you can have a 90-day window before they can actually use any accrued time. So, in other words, they'll accrue immediately, but you can say, hey, new employee, as of let's call it July 4th, you can't use it until 90 days from your first day of employment, even though it's in your bank. Now, with your existing employees, you have to allow them, they start accruing at July 1, 2017, and they're eligible to use it as they accrue it. So, there's a little difference in there between existing employees and employees hired on July 1, 2017 or later. But there is no need to pay out, but you'll want to hang on to those records for sure, because if that employee circles back around, they have to be reinstated with that accrued but unused paid sick leave. Record keeping, I think Becky had mentioned before that you have to keep the records for a total of 4 years. Now, there's a couple questions in here about what if I have a current PTO policy, how does that factor in? Well, if you have an existing paid leave policy, such as a general PTO, and a lot of people do, they just lump in, hey, you can take it vacation, you can take it sick, you can take a personal day, we just all put it in the same bucket. You can do that as long as they're accruing or have access to paid time off that at least meets the requirements of 206. So you have to figure out if you're a big employer or a small employer, as defined. Again, that cutoff is 15 employees, and it has to be accruing at the same level as Prop 206. But the only caution I would make here, because I don't want you to just say, oh, good, we're good. You have to be careful that you have to allow the employees to use that paid sick time for the same reasons in 206. So it's easy enough if they're for their own health condition, that's easy. Probably it would fit under your existing policy. I'm guessing if there's a family health issue, I'm guessing you don't overly care. Most employers don't. They say, hey, you've got PTO, you can take it for whatever you want. But be cautious about like legal proceedings, for example, on a domestic violence issue. That would be covered under 206, and so you'll want to make sure your current PTO is available to be used for things that are covered in 206. And so this is a great time to dust off those handbooks and those PTO policies and roll in the reasons and the ability to use the PTO for all the reasons set forth in 206, and then that way you're going to be covered.
We have a question here on right in line with what you're talking about, Josh, and it says, if I have a PTO plan that allows more than 40 hours a year of leave, can I still limit employees to 40 hours of, quote, sick leave used for purposes of law, under the law? So
the answer would be yes.
Yeah.
So you could have
a cap on.
You could put a cap on sick leave if you want.
Okay.
Yeah, as long as you allow for it for all those reasons that we just talked about. And Becky, you had mentioned as we were preparing for this, another thing right along this line too is if you have a general PTO policy that otherwise complies with all this and you're thinking we're good, don't forget about the posting requirements and the paycheck notice requirements too, because even though you might otherwise be compliant, if you fail on the notice and the accrual amounts and rates and where employees are currently each paycheck, make sure you roll that in there or you're going to run afoul of 206. And so, Becky, that was a great point that you had brought up earlier. Collective bargaining agreements, we didn't see a bunch on the participants here that were governed that may have been unionized, but just for those of you who might have hopped on that we missed, it does not apply to employees covered by a CBA to the extent that they're expressly waived in the CBA. So if there is a provision in 206 that says current CBAs are not affected, but new CBAs that come into effect or that are going to be negotiated either have to comply with 206 or expressly waive 206. And we don't get a lot of collective bargaining issues here, but if you do fall in that category, give us a shout because there's a few nuances in there for sure.
Let me just throw it while you're looking at the next one here,
Yep.
a couple of questions to try to answer. There's one that just came in and says, does an employer need to pay out any unused hours if employee terminates? I think we covered that already, and the answer is no. But if they rejoin within 9 months, you've got to reinstate whatever hours they had in that bank, correct?
That's exactly right.
Okay.
Yep. We've talked a little bit about the civil penalties and damages. There are attorney's fees, as if I didn't rain on the parade hard enough earlier. attorney's fees, and so I would be cautious about 206 and making sure we get that right. And I don't view the problems line with the minimum wage. I think that's going to be handled relatively easily. It's just paid sick time. And the good news is we do have several months, but Becky, to your point earlier, I think it's important to make sure your payroll system, I think the outsourced folks are likely to have the capacity to do this, but if you're doing internal payroll, or if you're outsourcing payroll to perhaps a smaller, less sophisticated company, I would start making those inquiries now to make sure that either they or you can handle these new reporting requirements, because there's going to be different line items on here to comply with 206.
Yeah, that's a good point.
Yeah. So, Becky, are there any other questions that we're seeing here as we're wrapping up? As Becky's looking there, just a quick note that recreational marijuana is not approved. We were the only state that did not approve it. In this most recent election, California did approve it. Some other states did approve it. Here, it was pretty overreaching how it was drafted, and that one did not pass here.
Okay. Yeah, we have a question here. Point of clarification says employees can only use 40 hours of sick per year, assuming it's the larger employer. So if this starts in July, are we supposed to use 12 months beginning then, or a calendar year? And I think Prop 206 talks about the employer has the right to choose what the year is, correct?
That's correct. So I think and I haven't looked at the nuances here, but if the employer has to start accruing this July 1 for sure. If the employer then wants to do kind of a half year and then start again with the new year, assuming that they continue to clip away at the same rate, I think they're going to be fine. I think that's going to be an internal accounting issue, but you certainly can't do less than the statute provides.
And some employers may decide, hey, whatever your beginning date for going forward, any new hires, they might start just on the date that they start. Yeah, that's right. Okay, so let's see here.
Which let me just mention there, and I know some employers are probably thinking, oh my goodness, we're going to have a different accrual year for every single employee. If you can get there, sometimes that does, as opposed to having everyone on the same calendar year, what that avoids is the rush of using paid sick time before that 12 months end, let's say at the holidays. And you might have like retail, for example, needs people around the holidays. So to the extent that you have kind of rolling 12-month periods for each particular employee, maybe that's not a bad thing because it helps even out the use right at the year-end rush.
We have another one here. It says, the company pays out unused PTO to an employee when they terminate. Can we separate this out by class of employees, like, say, temporaries, to not pay them for unused PTO? We know under Prop 206 you don't have to pay out at the end. So this company does want to pay out, but maybe a limit or, by classification. Do you see any problem on that?
Boy, that's a great question. I have not thought through that nuance for sure. It might be something I'd like to give a little bit more thought to.
It certainly, Prop 206 doesn't talk about that at all.
Prop 206 is silent. It doesn't say if you pay out for some, you have to pay out for all. You have the normal discrimination issues to deal with, but assuming those don't come into play, I'd like to think about that a little bit. And whoever asked that, feel free to reach out to either Becky or me, and we'll think through that a little. It's a great question.
There's another one here. Is there any restriction on employees using X number of days, I'm assuming sick days, and this as their final number of days before ending employment? So that's the example of, someone who has saved up all of their time. They know under the Prop 206 they don't get paid out for it. They're probably not going to come back within the next 9 months, and so they just turn up sick for the last several days. And I don't think there's anything in Prop 206 that talks about you can't do that.
It doesn't address it. It's similar to your regular PTO policy, and sometimes employees are very smart, and they see that they're going to resign, and so they happen to take a 2-week vacation and come back and turn in their resignation. So Prop 206 is silent on that. Once they accrue it, though, I will say they have every single right to use that under the law, and there's penalties associated if they can't use it. And it doesn't say if you're contemplating resigning, for example, there's some restrictions on that. It just doesn't say that. So I think we're stuck with the same rules, which is if they accrue it, they have the right to use it.
There's another question here is, do these rules apply to both exempt and non-exempt employees? And
They do.
Yeah, they do. Yeah.
Now, on the exempt employees, you can assume that they work 40 hours per week. If they work less, then you can do it based upon their normal working hours. But if they work more, you can assume the accrual rate ticks away at a normal 40-hour work week.
Yeah, and that kind of plugs into this next question. It says, so please confirm you accrue by the hour. So an intern or someone working 10 hours a week, it would take 3 weeks to earn 1 hour of sick time, right?
That's
and the
correct.
answer is yes.
Yeah, the answer is yes.
Yeah. So we have a lot more questions, and we are about at the 11 o'clock. Certainly feel free to log off if you want to. Josh and I will probably try to stay on. Is that okay with you?
Yeah,
for,
that's fine.
For a few 5 minutes or
sure.
so, and try to work our way through a couple extra ones of these. So feel free to hang on, and if you want to know our thoughts on these other ones.
Or feel free to hang up. It wouldn't be the first time someone hung up on me today.
Okay, so one of the questions is, how are local wage limits like Flagstaff enforced? And I'm assuming they're talking about the higher minimum wage in Flagstaff, and I don't know the answer to that.
I don't either. I think it's going to be a local Flagstaff agency that would enforce that. I don't think the state's going to do city-by-city enforcement.
Okay. Let's see here. You can look at some of these too.
Oh, sure.
Would a showing of an excessive number of non-paid sick leave absences suffice to overcome the clear and convincing standard? So here they're talking about, I think, the issue of if you take adverse action within 90 days of someone exercising their rights, and now the burden shifts to us to show by clear and convincing evidence we would have terminated them other way. Anyway, I think the question here is, could we use, he was absent a lot for paid sick leave reasons.
That would be certainly a good defense, I would think, if someone exceeded what they were entitled to. I'd be cautious here. I would instantly want to know, is it related to a disability? Because that could be an issue. Is it subject to FMLA leave? And did the employer, for example, provide the proper FMLA notice, assuming that the employer has more than 50 employees? So there's a number of factors that come into play here. But I think that would be a good factor if the employee was absent more and it's starting to affect operations.
I'd agree with
that. But I'd
that.
want to know a little bit more,
Yeah.
I think.
Here's an interesting one. It says, can employers provide the check stub information electronically? Must it be a printed stub?
It's silent in Prop 206. It does say it has to be on the paycheck. It doesn't say it has to be written. Which reminds me, though, let me make this point for employers. So the statute says that if an employee wants to take advantage of this paid sick time, they can do it verbally, in writing, via electronic means, or any other way that may be acceptable to the company. But then it goes on to say, if you as the company require notice of an employee taking this paid sick leave, and if you require them to give notice in some fashion, you must disclose that in a written policy and be able to prove you gave it in writing to the employees. So I would not rely just on a pure posting of that. I would somehow maybe roll it in a paycheck as we're getting closer to July 1st, maybe roll it in a handbook that gets signed, maybe roll it electronically. I would do a number of different ways to get the notice out. And again, the notice is if you require somebody to jump through some hoops about some notice, about how you give notice and when you need to give notice and who you need to give notice to, that has to be expressly in a written policy provided to employees, or else there's a violation of the statute. So you want a proof of how you gave notice.
And I think they talked about that in terms of non-planned sick leave. It's not like
non-planned sick leave.
Yeah, for non-planned. So things like you came down with the flu or something.
Yes.
It's if you're going to require something more than I just call I call my supervisor, then Josh is absolutely right. You've got to make sure that you make that clear to the people.
And so employers on this line for sure are going to want to get out ahead of, okay, what new policies do we need? How do we give notice to our employees? Are we posting the proper notices? Does the payroll folks, do they have the ability to put this on paychecks? Sure.
Okay,
One more question.
One more question here. So this one, it says, we offer a PTO policy. Currently they do. Employees earn 1.54 hours per month. Do we need to split this into two categories, sick time and vacation time? Well, I think the answer is you can have whatever PTO policy you want as long as it complies with Prop 206. So you'd have to have one that shows that you're accruing at the rate that Josh indicated, and that you can accrue up to the 40 hours or the...
Correct, and that, assuming someone's working full-time, that's not going to be enough.
1.54
per month, that's
yeah.
not going to do it.
Yeah. So whoever that is, and I won't name you, but you probably want to take a look at your
Yeah, I think we're going
to... PTO policy.
But you can have two different policies. You can have a sick time policy that complies with 206, and you can not have any other. I mean, there's no requirement other than this now. There's no requirement to pay vacation time anymore. There is a requirement to pay paid sick time. So if you need to adjust on the other side, that's something that employers can do. I wouldn't take away from what employees have already accrued, by the way, because you can run into some problems there. But if it's clipping away at 1.54 hours per month,
you're not going to meet it.
You're not going to meet it.
Yeah. I think the overall thing is, the idea here is, if you have a PTO policy or some kind of sick leave policy, you probably need to pull it out, look at it, and make sure that it complies with it.
In your handbook.
At least by July.
Yep.
So, thank you very much for joining us. Jamie, do you say anything? I think you do.
Yes, thank you. And this is the conclusion of the webinar. And on behalf of Snell and Wilmer, I'd like to thank everyone for joining us today. If your question was not answered, please feel free to reach out to Rebecca or Joshua, or contact your manager directly. And for a copy of today's presentation, please access the Handouts tab under the Conference Materials pod on the left-hand side of your screen. And you may now disconnect. Thanks again.